Hi everybody, the two Joes are back with our vlog series Claim 1 on behalf of HLK, and today we're going to be talking about all things video conference before the EPO. So what we're going to talk about is two things. We're going to talk about the referral to the Enlarged Board of Appeal, and we're going to talk about our experiences, in fact, because we've done many, or proceedings by video conference. So Joe, do you want to kick us off with a little bit of a discussion about a bit of an introduction and the background about what's been happening with the appeals?
Yeah, so video conference wasn't the norm. In fact, no hearings were held by video conference before the pandemic hit, and so that made the EPO change their approach to hearings. Opposition division became a pilot scheme to do them by video conference, and appeals weren't done by default. But around the end of 2020, the Board of Appeal changed the rules and introduced that the appeal hearings could be done by video conference if appropriate. And one of the key questions is whether it needed the consent of the parties in order to go ahead. So that is the background, and that is what has led to this latest referral.
Yeah, so the question of this referral was just published yesterday, actually. So it's a hot topic. The case in question is T1807 of 15, and in this case, it's an appeal case, and both originally the patent proprietor and the opponent stated that they didn't want to attend the hearing by video conference. They wanted to attend in person. But based on what Joe's just told you about the changes before the Board of Appeal, they decided to have it by video conference anyway. And one of the requests of the opponent, not the patent proprietor unusually, was that they still maintained that they didn't want to attend by video conference. And the reasoning was that they wanted to be in the proceedings themselves, in person, essentially in the courtroom, and they wanted to be able to read the board's reactions. So they decided that they refused to attend by video conference. They then subsequently withdrew their request, but that was enough. It's a big enough question at the moment that people want to know the answer to. So this has now been referred to the Enlarged Board of Appeal. And the question is the conduct of oral proceedings in the form of a video conference compatible with the right to oral proceedings as enshrined in Article 116(1) EPC, if not all of the parties to the proceedings have given their consent to the conduct of oral proceedings in the form of a video conference? So it's quite a broad question, isn't it, Joe? It doesn't seem to be just applicable to appeal from which it's derived, really, isn't it? The appeal proceedings.
And I think that's, one of the talking points is that Article 116 is applicable to all proceedings at the EPO, and so it goes beyond just whether this new rule in the or article in the rules of procedure. So that's the talking point, and I think, the question, the actual question came out yesterday. It's, video conference has been a big discussion point in the profession, and it's really tricky because it is a balance of the EPO don't want a huge backlog of cases and justice must be done, etc., versus the desire for parties to be there in person and in a sense have their day in court. So it'll be interesting, but I think there's an element of this isn't going to be sorted out overnight. There'll be amicus brief that will be submitted, and you'll see, I would imagine, a whole range of opinions on this subject, and it's going to be interesting to watch. But I think we'll keep you updated on what it is. But as I said, as Joe said, this is just out, so we're giving you a little commentary on it, and we'll keep you updated as things develop. Which I guess brings us nicely onto our experience of video conference. We as a firm have done quite a number of now video conference, both Board of Appeal and Opposition Division. And I suppose, my personal experience has been quite positive. I think everyone around the firm has had a positive experience. How have you felt it, Joe?
Yeah, I think it's been good for me personally. I think that we are very well set up at HLK to deal with them. We in our offices have a very nice space to run the hearings. And what I've found is that it's actually really nice to have to be able to just spread your notes about you or have everything on the screen in front of you. It really helps you to access things really quickly. So yeah, so positive for me. I've only done the oral proceedings before the opposition division at the moment, so no Board of Appeal for me. I know you've done Board of Appeal hearings. Have you found them to be different or?
They have. I mean, I think my feeling is that the video conference hearings are different to in person. I mean, I don't want to state the obvious, but they are. I think one of the things that I've found is that, you know, there's quite a lot of potential for screen fatigue. I've found that certainly in the opposition division hearings, there's no formal lunch break, which sounds sort of silly, but in fact, that hour where you go off and walk to the canteen at the EPO and you can really take time to regroup and think, okay, what next and where are we going to go and that sort of thing, that was missing. So that was an something we had to adapt to. And I think also the deliberation times felt shorter. I don't know if they actually were shorter, but they certainly felt shorter. And I felt like I was always at the screen and I had to force myself to get up from my seat and have a little walk around and that sort of thing. So different, but you know, as you said, our setup is set up really well for it. I feel that technologically it's worked really well.
Yeah. The interaction with the client's great, isn't it? Because you can just be having the hearing running by Zoom and having having a chat open with the client all the way through the hearing. And it also means that they can attend remotely as well, which is fantastic. It means there's no reason why they can't do that anymore. I mean, obviously the time difference may be a problem, but I know for my clients, they have been attending at ridiculous o'clock in the morning because they want to be part of it. I think it was the same in your one, wasn't it?
Yeah, and I just think, you know, it's really good for them to be able to do that and not have to fly transatlantic or all that thing. So that's a really positive thing. And yeah, I mean, I think, you know, it's hard. You know, you obviously don't know how the hearings would have gone in person compared to anything, but you know, I'm still winning cases, so I can't say that it's had a negative impact on any of the outcomes so far. So generally positive, but you know, I can go straight from a hearing and do bedtime, which is nice. So you know, generally our experience has been positive, but can absolutely see why people want to be in person hearings as well.
Yeah, I think this is it. I think it can be case specific. And I think, especially before the Board of Appeal, if there's lots of intricacies in the case, or you have multiple parties, or there, you know, the translation issue, it might just be that you want to be there in person. So you can see pros and cons for both, basically. And we'll just have to see how it plays out. It'd be very interesting anyway.
Yeah, I mean, I think, you know, we've had a positive experience. I think it's a good option. And you know, we, as you say, we'll have to see how things develop as fingers crossed, you know, the pandemic is changing the way that, you know, what we can do. So yeah.
Yeah, brilliant. And if anybody has any questions regarding oral proceedings in general or video conference, then please feel free to get in touch with us. And we will be back very soon with an
Yeah.
update on what's been happening.